Science, Tech, and Energy Committee, but it was constituent service that brought me to this issue. New Hampshire is a little unique from a lot of the other states, so I'll start off with our problem. It's my belief that the New Hampshire Circuit Court Family Division failures stem from a systemic due process violations inherent in the court's procedures, rules, and enabling statutes since 2005. Now, most of the cases have not been adjudicated by true judges in New Hampshire, meaning constitutional officers. The presiding officer has routinely been a marital master, a referee, or a retired judge who is no longer eligible to serve as a constitutional officer. So now they are all 3-year contractors. Contract judges are not subject to the New Hampshire Code of Judicial Conduct, so there is no official mechanism to address accountability or judicial malfeasance. In hearings, litigants and witnesses are typically not sworn in. There's no pursuit of perjury. So the Family Division in New Hampshire is publicly known as Liar's Court. Contract orders are required to be countersigned by a constitutional judge to certify that the correct legal standard has been applied. The supervisory judge of the Family Division testified regarding proposed legislation that it's virtually impossible for a real judge to spend the time needed to go through the file. And further, to get a clear understanding of the case without sitting in the courtroom, seeing the witnesses, judging their credibility, and listening to all the facts. His bill to repeal that judicial co-signature requirement was not adopted, so all the inadequacies and deficiencies of the process still remain. Now, one would expect the rules of the Circuit Court Family Division should be consistent with all the other circuit courts in New Hampshire. However, Rule 1.2 says, the Family Division may waive the application of any rule except where prohibited by law. Other than the New Hampshire Constitution or the U.S. Constitution, there are no prohibitions. Rule 2.2 states that New Hampshire rules of evidence do not apply. In case after case, litigants claim their ability to present evidence or gain discovery has been seriously or severely hampered because Rule 1.25 states the court at its discretion may limit or expand the scope of discovery in any case as justice requires. These rules apply whether the case is being heard by a constitutional or contract judge. So what are the consequences? Well, there are some contract judges that actually do a reasonable job, despite all the flaws in the system. Yet, for way too many abuses and violations remain, as you've heard here all day, very similar. The most common pattern with some of the worst consequences is protracting the cases interminably until the younger children reach the age of 18, which keeps the cash flow going for all the parties involved. This is done by giving primary custody to the least appropriate involved parent, too many times an abuser or totally disengaged or disinterested parent. The consequences: abuse, kidnapping, bankruptcy, loss of homes, loss of possessions, children failing to thrive, PTSD-like symptoms, and aggrieved parents who are left with nothing but desperate measures to even see their children. These horrendous decisions are often based on the contracts judge's assessment that reunification therapy with an abuser is an appropriate order, or supposed alienation of affections requires it. Now, case protraction is a nationwide problem, and it's propped up by federal law, Title 4D of the Social Security Act. Constitutional judges can't be paid with Title 4D funds, but all the contract judges and all the rest of the Family Division staff can. states have to certify that at least 20% of all their cases are protracted or complex in order to obtain federal funding. The act essentially incentivizes the removal of one parent from the scene. Title 4D was meant to address real parental abandonment. It is totally inappropriate for this act to incentivize the creation of a single parent and then restrict children's time with actual fit parents and penalize the same parents for not being involved. Finally, in New Hampshire, evidence was recently offered in a federal district court hearing that New Hampshire fails in family and relative reunification at a rate twice that of the national average and 3 times the rate for children with disabilities. So after, in my 3rd term, I've proposed this solution, which is to abolish family division. The idea is to return jurisdiction back to the Superior Court where it was in 2005. Superior Court offers the visibility into the system, and it also offers the opportunity for trial by jury. It operates with full due process for all the cases, and my proposal is that any case of child abuse, neglect, or domestic violence would be immediately moved to that court. My bill also created a new option for divorce mediation using the standards of the Academy of Professional Family Mediators. It's a well-recognized group that deals with just this focus. So the plan ensures due process rights for difficult cases, informed consent when choosing mediation, an opportunity to access the Superior Court if mediation is not working, and importantly, eliminates due process problems that plague the current family court system, reestablishing constitutional rights for our citizens to a trial in equity. Bottom line, the current family court system is unconstitutional and irredeemably broken. It can't be fixed with Band-Aids. Court rules institutionalize the absence of due process and fundamental rights. The family court is causing ongoing irreparable harm to families and children, and the proposed repair establishes due process and quality mediation alternative, and in the end, it's also likely to reduce costs to the state. So, with all this, I thank you for the opportunity to present today, and keep up the fight.